the core elements that any company should have. Absolutely, a human rights policy that's approved at the highest level that commits to certain kinds of governance aligned with the guiding principles. And that would mean conducting due diligence of a certain type at a certain frequency, committing to focus on specific rights that are most salient for that sector, that company.
Welcome to Sustainability Leaders. I'm Michael Torrance, Chief Sustainability Officer at BMO. On this show, we will talk with leading sustainability practitioners from the corporate, investor, academic, and NGO communities to explore how this rapidly evolving field of sustainability is impacting global investment, business practices, and our world.
The views expressed here are those of the participants and not those of Bank of Montreal, its affiliates, or subsidiaries.
Today, my guest is Yousuf Aftab, a partner with the law firm Steptoe. Yousuf focuses on business and human rights and sustainability law. Yousuf has been a pioneer in the field of law and human rights. Throughout his career, he has provided strategic advice to many Fortune 100 clients and served as counsel to the UN Global Compact. Today, we'll be discussing Yousuf's work on the UN Guiding Principles on Business and Human Rights, global sustainability regulations, and risks for companies and investors to consider in managing their business. Welcome to the show, Yousuf. It's good to have you on.
Thank you so much, Michael. It's a pleasure to be on.
Yousuf, can you start by telling the audience about your background and your journey becoming a lawyer and then focusing on business and human rights?
Yeah, sure. So the journey is a bit of a winding path. I, went to law school in Canada and then clerked and afterwards came down to a firm in New York, Latham & Watkins, where I specialized in international disputes, so mainly commercial arbitration and investor state arbitration. But one of our pro bono clients at the time was the UN Global Compact, which is one of the largest corporate sustainability voluntary initiatives in the world. And they asked us a question about these standards that were being developed that we'll end up talking about in further detail, but these standards on business responsibility for human rights that were in the draft stage, the guiding principles on business and human rights. And I started looking into these standards and got fascinated by their attempt to bring together public law concepts of human rights with private responsibility in a way that seemed to have a lot of promise. That I had traditionally seen the human rights world, or at least as it applied to business, as a bit of a marketing stunt. And when I saw these standards, it seemed like they could create a true framework for accountability. And so when I looked at the guiding principles, it seemed to me that legal expertise was going to be critical to implementing them effectively. And so soon after that, I launched a human rights strategy firm that was legally informed, and then that turned into a boutique law firm.
Can you unpack the UN Guiding Principles on Business and Human Rights? What do they mean? What's their genesis, and how are companies using them in the course of business?
Sure. So the guiding principles themselves are voluntary standards that set out what the responsibility is of states when it comes to human rights, and that is to protect, fulfill, and realize human rights, as well as to respect them. Then there's a second pillar, and this is the key one when it comes to business, that business has a responsibility to respect human rights. And then there's the third pillar is that both states and businesses have a responsibility when it comes to remedy for human rights. The second pillar is what was really novel about the guiding principles, because they took this concept, business respect for human rights, which before the guiding principles were endorsed was a bit of a meaningless concept legally, and they put contours around it. And they used as the contours to understand when a business respects human rights, they used a corporate compliance model. So they took lessons from corruption and money laundering and even health and safety and other rights, where they said, if you want to understand whether a company is actually respecting these rights, you would look at certain indicators of respect. One of those is the strength of policies. The other would be the strength of oversight. How high does it run? How active is the oversight of the risk? The third is a look at how companies assess and address those risks. And then the fourth element, and I think we can capture another here, maybe I'd make it five. The fourth element would be remedy. What kinds of programs do companies have in place to both receive complaints from those whose rights might be impacted and to address them? And then the fifth would be disclosure. How transparent are companies being when it comes to letting the public at large, but then also affected individuals, whether that is workers or communities, know about what the company is doing, what risks it's identified, and how it's trying to address those. The whole was basically a framework of best efforts to understand corporate respect for human rights.
And so you've noted that the UN guiding principles are a standard and they're interrelated with public international law concepts. Have there also been more local regulatory developments that you've observed where these topics are addressed or the guiding principles come into play?
Yes, absolutely. There's actually been a proliferation of local law, legal reaction to the guiding principles. I think that falls into several categories, but I'll say broadly, it started off with litigation. And there's a lot of litigation in Canada and the United States and the United Kingdom that focus on corporate responsibility for human rights, framed as negligent risk management or misrepresentation. But then government started to take another route as well to regulating corporate conduct when it came to human rights extraterritorially. And the legislative initiatives, there are too many to go through individually, but they fall into four categories. So there's mandatory disclosure law. That kind of law is similar to the Canada Modern Slavery Act, focuses on asking companies to disclose what they've done to address human rights issues across their supply chain. The second kind of law is mandatory due diligence law. And we're seeing more of this now coming out of Europe in particular. And there, the focus of governments has been to mandate that companies of a certain size implement due diligence measures, often tracking very closely what is in the guiding principles on business and human rights, including the scope and the prioritization of relevant risks. Then a third category we have not seen as much of, but I expect we will see more of in coming years, is around civil liability. And the exemplar in the United States is the Trafficking Victims Protection Reauthorization Act, which creates civil liability for companies that knowingly benefit from a venture that's involved in forced or child labor. That kind of liability then creates incentives to do due diligence of a certain kind and certain scope. Now, the most effective in some way, some would argue, type of legislation we're seeing more of it is trade regulation, non-tariff barriers related to human rights issues. So in the United States, there are prohibitions on importing goods made with forced labor. And then there are presumptions that can apply. For instance, if goods were manufactured, mined, what have you, in Xinjiang, China. In Europe, there's a forced labor ban that has a similar kind of scope in terms of what can be prohibited. But then beyond that, there are regulations specifically tied to batteries and to deforestation. And each of these has environmental components as well as human rights or social components. And they have substantial penalties associated with them. And I think we're going to see more and more of those kinds of legislation in coming years.
What are you seeing in terms of market drivers for the implementation of the UN guiding principles or related standards in terms of customer expectations in a marketplace or in a supply chain, expectations of investors? Is that a driver still of behavior of companies?
Absolutely drivers. What's interesting, I think, about drivers for corporate respect for human rights and the risks that companies need to think about. Makes this discipline different than others is that every risk has multiple dimensions. And so every risk, you're looking at a compliance dimension with various different types of regulation in different places. You're looking at a litigation dimension, civil liability, whether statutorily created or common law. But then you're also always thinking about brand risk and investor risk. And on top of that, now there's more institutional customer risk. When we first started, and when I started my consulting firm, that was 2012. I'd say between 2012 and 2016, the biggest driver was investor pressure. And the biggest driver for people to contact us, the biggest driver for people to build a program. That investor pressure would sometimes come from institutional investors like a BlackRock or a Vanguard, but more often than not, it would come from responsible investors who would file shareholder resolutions that were gaining increasing traction. And that would drive companies to say, all right, we should do something. The investor resolution might be something around developing a human rights policy or conducting human rights due diligence of a certain kind. Over time, that pressure, it became formalized. The investor pressure became formalized in various ESG ratings. Companies did care very much to do well on those ESG ratings. And those ESG ratings tracked and still do quite a few of the elements of the guiding principles in that they're looking for a governance-based approach to managing social risk. And that governance-based approach is often grounded in human rights, but we're looking at policies, due diligence, and the like. We have seen a bit of a pullback, and I think this is also borne out by statistics in general in ESG type resolutions, certainly in the States. And we've seen both in the number that are filed and in the kind of support that they are generating. And this is even before this year and this new administration, we'd seen that pull back in 2024. And I think part of the reason for that is a lot of those resolutions had become too prescriptive, too specific. Customer expectations have evolved more recently in the wake of a lot of the regulation, particularly in Europe, where companies that are caught by those regulations have to cascade them down through their supply chains. That language has gotten a lot stricter on what they're expecting of their suppliers. But I'm not sure that that's actually driving much change within companies. We are seeing that pressure increase in the contractual language, but often the people who are signing those contracts are not speaking to the sustainability teams or too closely to the broader legal teams.
So Yousuf, with that high degree of complexity, many different sources of expectations, how do you begin to advise your clients, multinational companies, big companies, small companies, on how to think about business and human rights and to begin to develop an approach to it?
I think the key thing is to recognize that each company is unique. Now, it's unique even if you were dealing with 3 oil and gas companies that are about the same size. Each will have its own organizational culture and structure. And it's important to realize that when you are developing a strategy around integrating human rights issues and risks into governance, it's critical to tailor it precisely to the company's operational footprint, supply chain, material risks, and organizational culture, because it is something where there are, if not infinite, myriad different ways to skin the cat, myriad different ways to manage risk effectively. What's critical is that it gets properly integrated. So when we start an engagement, and let's say the ideal engagement, I'd say is a company that has done a little bit around this, has buy-in from senior management and the board in order to build a program, it comes to us and says, "Oh, tell us what to do." And if we were to do that, the first step would be a comprehensive risk assessment. That is to understand both what are risks to stakeholders, whether that's workers and communities across the company's value chain, as well as risks to the company. And depending on where it's operating, is going to face different kinds of possible litigation risk, different kinds of regulatory risk, and have different kinds of exposure to trade-related risks. So we'd want to map all of that.
I know one of the issues that those sectors have begun to pioneer around grievance mechanisms and how to get feedback loops. But are there any specific sectoral thoughts you have in terms of unique challenges or opportunities? And then also, can you address the grievance mechanism developments? What's the latest thinking in that area?
Yeah, absolutely. So each sector does have its own specific kinds of challenges, and that's partly based on the way the guiding principles think about corporate responsibility. So if we pull back, the guiding principles, they talk about respect for human rights. They use a governance model. They define the scope of any company's responsibility for human rights based on involvement. So and there are three terms that are used, cause, contribute, and directly linked. But basically, you can break it down for either you're directly involved in a harm or you're indirectly involved in a harm. And depending on the sector, you're going to be more concerned about harms you're directly involved with than indirectly. So if we take resource sector, for instance, their concerns are largely going to be around harms associated with operations, with sites and projects, because those leave a massive footprint. They frequently lead to the building of effectively an entire new town, and they leave an environmental footprint and a community footprint that has these direct impacts. And when companies face risks, whether that's litigation, regulatory questions, or investor questions, they're often focused on those kinds of impacts. If you take the financial sector, by contrast, they are exposed largely indirectly. That is, the critiques that banks have gotten and that investors have gotten are because they have lent money or invested money in enterprises that are somehow involved with harms. And so what you are dealing with as a bank is a much greater scope of potentially affected individuals and harms that you need to think about. But the converse of that is that, or what's related to that, is because it's an indirect impact, the expectation of you as an enterprise is not to resolve everything, or it is to make sure that with this broad scope, you have shallower expectations, but you are thinking about it at a broad level. Whereas for a, mining company or an oil and gas company, actually the responsibilities are much more intense. You might have a much narrower scope of target rights that you have to think about on an ongoing basis, but you have much greater responsibility when it comes to each of those rights to address them in a way that's going to be satisfying to different kinds of stakeholders. So I think because of those range of concerns, the resource sector has been the most advanced in building governance. And there are a lot of lessons for companies coming to this more lately. And we certainly draw on them when we think about companies in the consumer product space, because consumer products companies, depending on their history, many would have come from thinking about this largely as a brand issue. And frequently you'll find that even the human rights teams would have been housed within some public relations function. And they're not as practiced at thinking about calibrating representations or thinking about integrated risk management and understanding exactly where they need legal and compliance folk to be weighing in. And the structures that have been built at resource companies are extremely helpful in drawing lessons for that.
And what about grievance mechanisms, Yousuf? I know that's an area you've done a lot of work in, and it's quite a tricky one. How are you seeing that concept evolve, and are there best practices that you're recommending in your advice?
Yeah, so grievance mechanisms, I think, is now, when it comes to human rights governance, that is the frontier we're all still exploring. But grievance mechanisms, there are many types. And so what the guiding principles envisioned were what we call operational level grievance mechanisms. And that, I think, is most apt for a project like a mine or an oil and gas project, where you ensure that people have a way, from the community, have a way to lodge complaints and process them. We've gotten to a world now where the expectations in the EU Corporate Sustainability Due Diligence Directive, the German Supply Chain Due Diligence Act, frankly, even arguably the Norwegian Transparency Act, are much more expensive. And it's not just that people around a particular operational site need to be able to file grievances. In fact, it needs to be anyone affected or with a legitimate concern anywhere in the supply chain of a given company. So that could be many, many tiers down, right? Suppliers that you might not even know about. What that means is you've got a much more expansive kind of mechanism, which nonetheless needs to be able to handle these complaints fairly. I think the model for building an operational level grievance mechanism is very well canvassed. There's a lot of good public literature out there on how to do this. Many have been attempted, and the framework, I think, while they can always be perfected, there's a lot of guidance. The supply chain type of grievance mechanism and the kind of mechanism that now financial institutions are wrestling with, that is much less certain. So it's something we are doing a lot of work around, but a lot of our work is experimentation at the moment.
You've noted that many different jurisdictions have quite different approaches to this topic. So in Europe, you're seeing due diligence expectations set by regulators, duty of vigilance, which essentially creates a due diligence expectation. And in the US, you've got potential for civil liability. There's importation restrictions on forced labor or products associated with forced labor. In Canada, there's been some corporate law cases. So with that very differing landscape, are there some key elements of a good human rights program that companies can begin to adopt no matter where they're doing business that would be, I guess, essentially a high watermark for managing the topic?
Absolutely. I mean, I think it is important to realize that, while we have this suite of different kinds of regulations and kind of legal liability, while there are some tensions, those tensions need to be noted, but they can be navigated, right? It's more a matter of considered approach. But the core elements that any company should have, absolutely a human rights policy that's approved at the highest level, right? Ideally by the board, that commits to certain kinds of governance aligned with the guiding principles. And that would mean conducting due diligence of a certain type at a certain frequency, committing to focus on specific rights that are most salient, most relevant for that sector, that company, and then committing to a form of a grievance mechanism. Now, there are, as we said, there's complexity here, but you absolutely want to commit to doing your best to receive, fairly process, and address in line with the guiding principles complaints from different kinds of stakeholders who might be affected by your actions.
Thanks, Yousuf. Are there any final thoughts in terms of what you're watching in this space or that our audience should be focused on?
Several. One thing I would stress is that, and we're seeing this a bit, something that's in the zeitgeist. It is something that we are certainly working on ourselves more with our clients. There's much more room and much more of a desire for collaborative approaches. I think with a lot of these issues, companies coming to them can think it's quite daunting, but there are ways to test solutions and governance approaches that manage legal risks that can be done efficiently, that can be done collaboratively. And I think that's something everyone ought to be thinking about, especially those coming to this early days, but also more mature companies. The other point I'd mention is we've talked a lot about risk, and it's natural to talk about risk in this space, but there's also a lot of opportunity. And that opportunity, the element of opportunity that has to do with actually recognizing that you as a company are doing good and having impact, but there's also opportunity to build relationships with key stakeholders that pays dividends. There's opportunity in terms of building a brand. And I'll say, as an example, any program that works well and is implemented in line with the key voluntary standards and laws depends a lot on stakeholder engagement. And stakeholder engagement might mean talking to experts like Human Rights Watch or Oxfam or various professors, but it also means frequently speaking to very vulnerable communities, whether that's around a project or workers in a supply chain. A lot of companies are quite afraid of taking these steps because they're not sure what information they're going to get. It feels like it could create tensions. We've seen the hesitance increase, but we've also seen when companies do it right, it serves a great purpose. Right? So there was a company that had done a lot of stakeholder engagement before, And then after these issues arose, and so was in a position when questions came from regulators, when questions came from investors, was in a position to say that we have these groups that stand with us, these credible groups that you trust. Another example was one from a few years ago where we were working with a company exposed to the agricultural supply chain in Indonesia. And in that supply chain, a lot of work is done through brokers, but a number of the big brands exposed to the same sector were criticized in a Human Rights Watch report about child labor in agriculture in India. But the client we worked with, which had been working with key civil society groups to build its program and to engage, was the only one that was complimented in that report. And at the, notwithstanding the fact that everyone faced these risks, our client was the one that was identified by Human Rights Watch as the one that had engaged in good faith, that had been trying its best, notwithstanding complicated circumstances, and was then in a position to actually hold out this report that was quite critical of the sector, but hold it up to investors and regulators and say, of course, we're not perfect, but we are ones that are trying. And that is a great opportunity, because where it comes down to it, the risks that are greatest for companies still emerge in the crisis moment, and proper engagement, proper due diligence really prepares companies both to understand where crisis might arise, but also to react once they do.
Great insights. Thank you very much for your time today, Yousuf.
My pleasure. Thank you so much for having me.
Thanks for listening to Sustainability Leaders. This podcast is presented by BMO. You can find our show on Apple Podcasts, Spotify, or your favorite podcast player. Press the follow button if you want to get notified when new episodes are published. We value your input, so please leave a rating, review, and any feedback that you might have, or visit us at bmo.com/sustainability leaders. Our show and resources are produced with support from BMO's marketing team and Puddle Creative. Until next time, thanks for listening, and have a great week.
For BMO disclosures, please visit bmocm.com/podcast/disclaimer